Does a prenuptial agreement protect your estate? Well, it really depends on what your prenuptial agreement says. But yes, a prenuptial agreement is supposed to clearly indicate that one spouse owns this set of assets, another spouse owns that set of assets, and that they have a right to dispose of their assets as they choose. Now, in Washington State, where I practice, it's important that the prenuptial agreements be prepared by separate attorneys so that the spouse one has their own attorney, spouse two has their own attorney. That's to make sure that the prenuptial agreement is equitable, is fair, and will withstand any kind of attack by one spouse or the other. So theoretically, yes, a prenuptial agreement is to confirm who owns what and allows the spouses to pass them on their death where they want them to go. One of the things that people in Washington, spouses in Washington, are sometimes surprised to find is, well, what happens during the spouse's lifetimes if one spouse needs long-term care? So let me give you an example. I worked with some clients who came to me. The one spouse, the husband, required expensive long-term care. The other spouse did not. She had an estate of well over $1 million. His was far, far less. The spouse with all of the money was surprised to learn that despite her prenuptial agreement, the state of Washington would count all of their assets as joint assets for the purposes of determining Medicaid eligibility, because it was very easy to spend the one spouse, the ill spouse, down to $2,000. At $12,000 a month, his money was going to go away quite quickly. And the family wanted him to receive state benefits, Medicaid benefits, to pay for his long-term care. They filed a Medicaid application, and the state said, well, maybe he has less than $2,000, which is a single person limit, but she has over $1 million. So no, there's not going to be any Medicaid benefits award. She said, but I have a prenuptial agreement, and it says that this money is mine, not his. And the state says, you're married. So regardless of what you agreed in your prenuptial agreement, that's irrelevant to the state's determination of benefits eligibility, which meant that she needed to pay for his long-term care costs, and that was an unpleasant surprise to her.